Hello, everyone. This is Judge Clutter at the Office of Tax Appeals. Looks like everyone um, may be here. We're gonna go ahead and start our hearing. This hearing is being held today electronically with the agreement of all the parties. Let's go on the record. This is Appeal of Kaplan. It's OTA case number 2405-16191. Today is Thursday, July 24th, 2025, and the time is 9:30 a.m. As I mentioned, I'm Judge Clutter. With me are panel members Seth Elsom and Sarah Hosey. While I am lead panel member in conducting this hearing, all three panel members are co-equal decision makers. The Office of Tax Appeals is not a court. We are an independent appeals body. The Office of Tax Appeals is staffed by tax experts and is independent of the state's taxing agencies. To ensure that we have an accurate record, we ask that everyone speak one at a time and does not speak over one another. Please speak clearly and loudly. This video recording is part of the public record, and this proceeding is a live broadcast. Any information shared on your screen is publicly viewable, so please be mindful. A pre-hearing conference was held for this appeal on June 11th, 2025, and orders were issued on June 16th, 2025. The minutes and orders set a deadline for submission of new exhibits and objections of July 9th for new exhibits and objections on July 16th, 2025. Following the issuance of the minutes and orders, the parties submitted additional exhibits. Franchise Tax Board submitted exhibits Z through FF, and appellant submitted documentation that we'll be calling Exhibit 2. No objections were submitted in writing. Before I proceed with the hearing, I just wanted to ask for appellant and Franchise Tax Board, do you have any matters to raise with respect to the minutes and orders? Are there any new exhibits today? Or do I have that correct? Beginning maybe with Franchise Tax Board.
No, Judge, we are no issues, nothing new.
Okay, and for appellant?
I don't have any new exhibits to add. I do have an issue with the latest exhibits that the FTB submitted. I didn't. Is that something you want to hear from me right now, or do I just say I have an issue with it and we'll handle it as we handle
it? Yeah. What is the issue?
The issue doesn't show jurisdiction. It's a penalty assessment, but it doesn't show that they can do that.
That's something that you can address in your argument. But I'm just trying to understand now if all the exhibits were received and that, things of that nature. But thank you for letting me know about that. Are there any questions that the parties have or anything like that? If there's any issues that arise about technology or any questions during the procedure like you just did, Mr. Kaplan, you can direct them to me. I'm going to ask also my panel members if they're ready to proceed. Okay, with the nod, it looks like a yes. So if I can please have each of the parties, beginning with appellants, just identify yourself, state your name for the record, beginning with appellant.
My name is Charles Kaplan.
Thank you. And for Franchise Tax Board?
Eric Brown, Franchise Tax Board.
Ellen Swain, Franchise Tax Board. Good morning, everyone.
Good morning. Thank you. And the issue, as I understand it, is whether appellant is entitled to a refund for the 2019 through 2022 tax years. As I mentioned in my minutes and orders, I considered alternative statements. And if you would like to add anything, you can do so in your argument during your presentation. With respect to the evidentiary record, as we just previously mentioned, FTB submitted exhibits A through FF, and appellant did not object to these exhibits. Therefore, these exhibits are entered into the record. Appellant provided exhibit 1 and 2. FTB, Franchise Tax Board, I'm sorry, did not object to those exhibits. Therefore, those exhibits 1 through 2 are entered into the record. As a reminder, we have 35 minutes. Appellant, you will have 15 minutes for your presentation. Franchise Tax Board will have 10 minutes, and then appellant, you will have 5 minutes for your closing statement or rebuttal. Mr. Kaplan, before you begin your presentation, I would like if you could please raise your right hand so that I can swear you in for any testimony you might provide.
Yep.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, so you'll have 15 minutes for your presentation, and you may begin.
Okay. I'm just and make sure you can hear me correctly, yes?
Yes, we can hear you.
Okay, great. Okay, so I want to give you guys everybody some background on where I'm coming from here. I work in California in Los Angeles. I am compensated by a company that I do not work at. I don't work on site for them. I don't report to them. They don't manage my daily operations. What I do is basically I produce artwork and some organization for files and things like that. Very local work. And what my work, I give my work to the people who hired me, and that what they do with it is really not my concern. Where it goes after that, I'm not exactly sure. I have some ideas, but it's not really within the purview of my job. Um, so so when I've sent paperwork into the FTB, and I've for 2019 through 2022, I have attempted to correct this paperwork. It's more administerial, clerical corrections, and status updates. So to me, what this comes down to is really this is a jurisdictional case. Does the FTB have jurisdiction to demand this money from me, and is it right for them to do so? And so what we need to look at is the jurisdiction. And FTB is, since it's a government agency, it's a special and limited. They have special and limited jurisdiction, which is defined by codes and statutes. They cannot just make up their own jurisdiction. They need to follow what it is. And if they're operating outside of jurisdiction, anything they do is void from the start, ab initio. And FTB, they just can't assume jurisdiction without proof of jurisdiction. And what's happening here is the company that is compensating me is reporting to the FTB that I earn income and wages as defined in the IRC, which is not true. And they just they don't change what they're, even despite my attempts to tell them it's wrong, they just still keep reporting it that way, and everybody's misinformed. So this is the point of my appeal, is to inform, and set the record straight. Just so you know, the IRS did return. That's the exhibit 2 that I submitted. The IRS did return money that I had sent to them for 2019. So they've agreed that they don't have jurisdiction, especially for that year. I've heard they're working on other years at the moment, but so far they've agreed to that. I've told FTB that my status is one of the people of the U.S., which is not the same as a citizen of the U.S. Completely different. It's a people of the U.S. As contemplated in the U.S. Constitution, the preamble. That's where you find it. And FTB has had no objections to my status, either submitted to Entertainment Partners, which is the company that pays me, or FTB. No one's had any objections to it. So that is my status. And just so we know, I'm going to quote something from the American Banana Company and United Fruit case. It's a U.S. Supreme Court case that said the foregoing considerations would lead in case of doubt to a construction of any statute as intended to be confined in its operation and effect to the territorial limits over which the lawmaker has general and legitimate power. All legislation is prima facie territorial. Words have universal scope, such as, quote, every contract in restraint of trade, or every person who shall monopolize, etc., will be taken as a matter of course to mean only everyone subject to such legislation, not all that the legislator subsequently may be able to catch. So it's accepted that the jurisdiction is important. The territories of the jurisdiction is important to this. So as far as status goes, and to understand what my status is and what other people's status is and how it relates to the FTB, there's different examples of scenarios. For example, the FTB doesn't have jurisdiction over a Canadian person in Canada not doing any business with the U.S. They're outside California. They're outside in another country. It's outside jurisdiction. Likewise, if a Canadian tourist comes to California, they're just enjoying their time, going to Disneyland. They're not subject to FTB taxation just because they're inside California. So just because you're inside California doesn't mean that one is subject to FTB taxation. Another example is an American dock laborer, which is subject to FTB, or not FTB, sorry, to IRS at least, because it's involved in commerce. That person is subject to tax from the IRS. However, up the coast in Vancouver, the same of the jurisdiction. So what's very important is the people of the U.S. or the people of California are not subject to the jurisdiction of the agencies that serve them. And there's quotes in the Bagley-Keene Act specifically says that the people don't, they do not, let me find this here. They basically don't give up their sovereignty to the agencies that serve them. That's in, I can.
It looks like Mr. Kaplan has lost connection, so we're going to take a 2-minute break and hopefully he can reconnect. So just sit tight. We'll go off the record so he can reestablish his video and then we'll continue forth. Thank you.
Can everyone hear me?
Yes, this is Judge Clutter at the Office of Tax Appeals. I think you may need to stop your video just because, at least on our end, we're having issues with like lagging or I don't think maybe you have the most stable connection. So if you stop your video, maybe you'll be able to have a more smooth. It won't take as much data to. But we lost you some time ago. You were, but I think, yeah, I'll just, the last place was discussing the Bagley-Keene Act. And I just want to remind you, at that point in time, I think you had, I'll just allow you like approximately 10 more minutes. It's hard to say, but yeah, you'll have until 9:54 to conclude your presentation, but please keep going. Sorry, we lost you.
Yeah, no, that's okay. So thank you for that. Let me get back to where I was here. Yeah, so the Bagley-Keene Act is it's quoted twice in the Bagley-Keene Act where it says the people of the state, meaning of California, do not. Let me get back to that. Yeah, the people of the state do not yield their sovereignty to the agencies which serve them. So the people of of California are have general jurisdiction, whereas the FTP does not. And the people of California can only contract into anything with the FTB. The FTB cannot just assume general sovereignty over them. So I've been very clear in the last between 2019 and 2022 over what my status is, and I can change my status if it's recorded somehow in their records, and I can call the FTB and clarify this, or write them and clarify what my status is. For example, someone can do that, like if an American is moving to Canada or China, say, and they need to renounce their citizenship. That's a very easily understandable change of status that everybody understands. However, it doesn't seem like it's clearly understood what my status is and how it's changed in their records. So everybody is just at the FTB seems to be assuming what the old status was in their records is as the same status as today, despite my informing them over and over again, writing and in person, to tell them this isn't the case. So, okay, so where I was going after that was it's very important that, because what I said earlier, that the FTB is they do have special and limited jurisdiction, and their terms are defined explicitly in the IRC because the FTB does defer to the IRS for definitions. And for example, an employee in the IRC is someone who those terms are defined, and I'm going to bring those up for you. Stand by. So basically, if you go through the IRC, which is a tough and tall task, you can find what the definitions mean. For example, commerce, it has to do with interstate business and foreign business with other countries. In 5 USC 8401, employee means a congressional employee, firefighter. There's other sections of USC that define it as Congress people, or the president, or members of Congress, or railroad workers, where there's actually interstate commerce, or airline carriers. This is all what an employee means, and employees, work for either government agencies or like the military. That's you work for the military. That's an employee. So what I described to you at the beginning, that does not fall under the definition of employee, and we must follow the definitions. The FTB can't make up its own definitions. It's defined for it in the IRC. So and an employer is somebody who employs employees, like a railroad company or an airline or a government agency, et cetera. So I don't fall into any of those categories, and that's been my argument from the start in writing for years, and it's been ignored, and hence that's why we're here. Let's see, about 5 minutes left. And also, 4 USC 72 requires that all public offices be exercised in DC and not elsewhere, except as expressly enacted into law by Congress. And the term trade or business is part of terms for income and employee. Someone who's an employee earning income must be involved in a trade or business, and trade or business includes the performance of functions of a public office. It's very clear. That's 26 USC 7701 A26. And applying a law concept to that of expressio unius est exclusio alterius, which means the mention of one thing implies the exclusion of others. So if something says trade or business includes the performance of the functions of a public office, It doesn't mean anything else. It doesn't mean like, oh, and there's also some other things that we haven't mentioned but are included. No, it's very clear. It is a public office, and I don't work for a public office. I don't have public office. When certain, this is Black's Law Dictionary, 6th edition, when certain persons or things are specified in a law, contract, or will, an intention to exclude all others from its operation may be inferred. Under this maxim, it's if statute specifies one exception to a general rule or assumes to specify the effects of a certain provision, other exceptions or effects are excluded. So that's basically, I'm basically, the crux of my argument is that the FTB does not have jurisdiction to claim taxes from me. And they've made an effort to, in their reply, when I first submitted my appeal, they made a big effort to claim, to show that I'm a tax protester, which I'm actually not. I 100% support taxation. This is not a taxation support a protest issue. There are people out there who call themselves, agree to being taxpayers, the term taxpayer, but they also say they're not. That's a protest. I am completely for FTB taxation, IRS taxation. However, I, like a Canadian or a Mexican person who doesn't do interstate commerce, I'm outside of the jurisdiction of the FTB, and therefore I'm not subject to FTB taxation, the way they're claiming taxation. That's not. I'm excluded, and I'm not eligible. Is really what it is, and that's based on the definitions from the IRC. So that's my opening argument.
This is Judge Clutter. Before I turn it over to Franchise Tax Board, you mentioned that you wanted to address something about FTB's exhibits. So do you mind doing that, in the 2 or so minutes that you have?
Yes, of course. Thank you, Judge, for asking. Yeah, so since the FTB does not have jurisdiction, they cannot impose arbitrary penalties. So their exhibit that they submitted was penalties from them, that basically penalties that are just that don't have jurisdictional backing. Because of my whole argument that I just argued for the last 10 minutes. That's it falls under the same non-jurisdictional demand. So they're without authority to do that.
Thank you, Mr. Kaplan. I'm going to turn it over to Franchise Tax Board. Mr. Brown, are you ready to begin your presentation?
I am ready.
You will have 10 minutes. Please begin.
Thank you. Good morning. I'm Eric Brown, attorney for the Franchise Tax Board. Also appearing for the Franchise Tax Board is Ellen Swain. In the present appeal, appellant has failed to show error in the Franchise Tax Board's denial of its claims for refund for any of the tax years in issue. FTB's denials for each year were in response to appellant's frivolous amended tax returns. For tax years 2019, 2020, 2021, and 2022, appellant filed timely, valid California income tax returns in which he reported accurate values for wages, taxable income, and taxes. In December 2023, appellant filed amended tax returns for each tax year, and each return was a, quote, zero, unquote, return in which he claimed zero wages, zero taxable income, and zero tax liability, while claiming a refund of all of the taxes withheld by his employer or for which he paid for the entire tax year. In the amended returns, appellant explained his reasons for filing an amended return, included that he is not subject to California taxation because he is not involved in a trade or business, is not a government employee, is not an officer or of a corporation, nor is he a U.S. citizen for purposes of taxation, nor is he subject to the jurisdiction of the United States regarding taxation. Appellant's arguments have long been deemed frivolous and have been consistently and emphatically rejected by the Office of Tax Appeals, State Board of Equalization, the appellate courts, and the IRS, who have all found the arguments to be frivolous and without merit. In the 2018 OTA precedential opinion of Appeal of Balch, the OTA rejected the argument that the Balch appellant did not receive wages and that wage income was not taxable. The OTA reemphasized that the argument was frivolous and rejected it in its entirety. In the present appeal, appellant's arguments are almost identical to those presented in Appeal of Balch and warrant the OTA's emphatic rejection. Appellant's claims that the FTB lacks jurisdiction to tax appellant based on his claimed status involves arguments that arise under the California Constitution and other California and federal statutes. Such jurisdictional arguments are beyond the scope of the OTA's jurisdiction to hear tax disputes. I would be happy to respond to any questions.
This is Judge Clutter. I think we're going to hold questions until the end, but that concludes your presentation, Mr. Brown.
That is the end of my presentation. Yes,
Okay.
thank you.
So before we ask any questions, I just want to turn it back over to Mr. Kaplan. Mr. Kaplan, would you like to make a final statement, rebuttal to what Mr. Brown said, or is there anything else that you've prepared or would like to say before the case is submitted?
Judge Clutter, I would just like to respond to what Mr. Brown said. I don't have anything else. I don't think so. I just wrote down some notes here to his argument, and I just want to respond.
Yes, please go ahead. You'll have 5 minutes.
Okay, let me set my timer here. Okay, thank you. So one point Mr. Brown made was I failed to show error. And I completely disagree with that because I explained to them in writing that my correct status, and based on the correct status, they should know that I'm outside of jurisdiction based on that status. It's as if I didn't, but I'm saying in a made-up scenario, if I had told them I don't live in America anymore, I live in Canada now, I'm a Canadian citizen, I denounced my U.S. citizenship, et cetera, they would understand, oh, okay, yeah, that's change of status. Okay, we'll adjust it on our end. So what I did tell them about my status as one of the people of the U.S. and what that means and where it's coming from and why it's backed by the U.S. Constitution and U.S. Supreme Court cases that I've mentioned in my original appeal, I do have showed enough evidence. I've shown enough evidence to show that there has been error over at the records at the FTB, and especially with entertainment partners submitting, basically the FTB is relying on entertainment partner as an authority, which they're not. They're just somebody who, is paying me. So I've shown enough error. I mean, I'm sorry, I've shown enough evidence to show that there has been error over at the FTB on my record there. The FTB mentions that my arguments are frivolous, which I don't believe so. They're based in U.S. Supreme Court law. They're based in 800 years of English and American, English adopted law in America. It goes back centuries. Let's see. Yes, I said I have zero tax liability as far as the FTB is concerned. I'm happy to pay taxes as long as the agencies are following the guidelines of their definitions and how they need to operate in the codes, which they're not in this case. FTB mentioned an employer. I don't have an employer. If Entertainment Partners is posing as an employer, we would need proof of their being an employer, like they hire military or railroad workers, dock workers, airline people. That's what an employer is. They would need to define it. If they want to call themselves an employer, like if a company calls themselves a bank, they would need to prove that they're a bank. They would need to show the paperwork that they started a bank. You have to prove it. You can't just walk around and say you're a bank and everyone assumes you're a bank. So if EP Entertainment Partners, if they're claiming to be an employer and they have to prove it at some point, which I don't think they can because they, as far as I know, they don't hire what the IRC defines as employees. Um, uh, I say yes. I'm okay. Well, it's frivolous. Wages. I wanted to go over when we say wages. Let me go to my wages section here. Bear with me 1 second. I find it. Believe. Let's see. Yeah, wages. Okay. For the purpose of this chapter, the term wages means all remuneration for employment, et cetera, et cetera. So wages in the IRC is defined as remuneration for employment. And since I'm not an employee and Entertainment Partners is technically not an employer, I don't make wages. So I'm not eligible, even if the FTB calls it wages, it's not, in substance, it's not wages. And then my last point would be just answering Mr. Brown is that my argument is I read all the arguments that they've put forth and the cases that they've pointed to in the past, and my argument is completely separate and different, very different actually. From they say FTB is saying it's almost identical to past arguments that are frivolous, and I argue that because my argument is backed in definitions and codes and statutes and jurisdiction, it's not identical at all. I'm defining where the boundaries are for the FTB. I'm claiming that I'm outside those boundaries, just like a Canadian citizen would be in Canada, even though I'm inside California. And that's the meat of my argument, really. So that's all I have to say.
Thank you, Mr. Kaplan. I'm going to turn it over to my panel. I do not have any questions, but would like to ask Judge Hosey. Do you have any questions for either party?
No questions from me. Thank you for your presentations today, though. I appreciate it.
And Hearing Officer Elsom, do you have any questions for either of the parties?
I did have one question for Mr. Kaplan. It looks like you had amended your 2019, 20, 21, and 22 returns all on the same date, which was December 26, 2023. And you have a lot of very complex law cited and legal analysis. And I was wondering how you arrived at that conclusion that that your income was not taxable, meaning did you conduct this analysis on your own? Did you do legal research? Maybe was there a tax preparer that you'd met with, or did you attend a seminar? Can you just speak a little bit to that, to how you arrived at this position and, where you obtained the legal resources?
Yeah, sure. Most of it is my own research. I've had just help along the way from people who point out certain parts of the code that, like, for example, people have pointed out to me the definitions are very important and they need to be followed. So I start looking at definitions, and if I have a question about it, the IRC, the code is very hard to decipher. It's not very clear, and you have to follow trails. So what I would do is for example, I would find a section that describes what an employee is, and I say, okay, here's the definition, but there's terms in there that are legal terms, not street terms. Like I can't, the legal language is a complete, like someone, for example, someone along the way a lawyer that I talked to said that the legal language is a completely separate language than what we use in the classroom or in business. So you have to look at every word legally as you have to go into the words and phrases section of the law library and actually look up the cases that have argued the definition of this word. And what you'll find is that there's a lot of words mean different things. For example, on the street, when we talk on the street in our capacity as just people on the street, when I say I'm a resident of California, you know that to mean I live here in California. However, if you look in the definitions under what is a resident, and it actually is somebody who crosses a border for the purposes of usually something commercial, and then they go back to from whence they came when they're done. For example, a doctor who's studying to become someone who's studying to become a doctor does a residency. They enter the jurisdiction of another hospital, and do as they say in that hospital. And when they're done, they go back. Like when someone does like a entertainer does a residency in Vegas, they will go perform for the purpose. Let's say they live in New York. They come to Vegas, cross the state line into Vegas. They do their work that they're intending to do, and when they're done, they go back to New York. That's what a resident is. And I'm actually domiciled in California, which means, and domicile is the meaning of that, is the legal meaning of I live here. So yeah,
Mr. Kaplan, I think you've covered my question adequately. I appreciate
Okay.
the response. Thank
You're
you for
welcome.
the detail.
You're welcome.
Thank you, everyone. So now that our questions have been answered and the presentations have been made, this concludes the hearing. This panel will meet and decide the case based on the evidence that was presented, including the testimony, and this panel will issue our written decision no later than 100 days from today. This concludes this hearing session, and we are no longer on the record. And just as informational for everyone, the next hearing session will begin at